Okay, Proximate Cause, Attenuated Doctrine of Chapter 3, discussing the scope of the exclusionary rule. And I'm going to read New York v. Harris, a 1990 case. Justice White delivered the opinion of the court. On January 11th, 1984, New York City police found the body of Miss Thelma Staten murdered in her apartment. Various facts gave the officers probable cause to believe that the respondent in the case, Bernard Harris, had killed Miss Staten. As a result, on January 16, 1984, 3 police officers went to Harris's apartment to take him into custody. They did not first obtain an arrest warrant. When the police arrived, they knocked on the door, displaying their guns and badges. Harris let them enter. Once inside, the officers read Harris his rights under Miranda v. Arizona. Harris acknowledged that he understood the warnings and agreed to answer the officers' questions. At that point, he reportedly admitted that he had killed Miss Staten. Harris was arrested, taken to the station house, and again informed of his Miranda rights. He then signed a written inculpatory statement. The police subsequently read Harris the Miranda warnings a third time and videotaped an incriminating interview between Harris and a district attorney, even though Harris had indicated that he wanted to end the interrogation. The trial court suppressed Harris's first and third statements. The state does not challenge those rulings. The sole issue in this case is whether Harris's second statement, a written statement made at the station house, should have been suppressed because the police, by entering Harris's home without a warrant and without his consent, violated Peyton v. New York in 1980, discussed supra on page 205 of this casebook, which held that the Fourth Amendment prohibits the police from effecting a warrantless and non-consensual entry into a suspect's home in order to make a routine felony arrest. For present purposes, we accept the finding below that Harris did not consent to the police officer's entry into his home and the conclusion that the police had probable cause to arrest him. It is also evident, in light of Peyton, that arresting Harris in his home without an arrest warrant violated the Fourth Amendment, but as emphasized in earlier cases, we have declined to adopt a per se or but-for rule that would make inadmissible any evidence whether tangible or live witness testimony, which somehow came to light through the chain of causation that began with an illegal arrest. Rather, in this context, we have stated that the penalties visited upon the government and in turn upon the public because its officers have violated the law must bear some relation to the purposes the law is to serve. In light of these principles, we decline to apply the exclusionary rule in this context because the rule in Peyton was designed to protect the physical integrity of the home. It was not intended to grant criminal suspects like Harris protection for statements made outside their premises, where the police have probable cause to arrest and suspect for committing a crime. Peyton itself emphasized that our holding in this case stemmed from the overriding respect for the sanctity of the home that has been embedded in our tradition since the origin of the Republic. Although it had long been settled that a warrantless arrest in a public place was permissible as long as the arresting officer had probable cause. See United States v. Watson, 1976. Peyton nevertheless drew a line at the entrance to the home. The special solicitude was necessary because the physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. The arrest warrant was required to interpose the magistrate's determination of probable cause to arrest before the officers could enter a house to effect an arrest. Nothing in the reasoning of that case suggests that an arrest in a home without a warrant but with probable cause somehow renders unlawful continued custody of the suspect once he's removed from the house. There could be no valid claim here that Harris was immune from prosecution because his person was the fruit of an illegal arrest. United States v. Cruz. 1980. Nor is there any claim that a warrantless arrest required the police to release Harris, or that Harris could not be immediately rearrested if momentarily released. Because the officers had probable cause to arrest Harris for a crime, Harris was not unlawfully in custody when he was removed to the station house, given Miranda warnings, and allowed to talk. For Fourth Amendment purposes, the legal issue is the same as it would be had the police arrested Harris on his doorstep, illegally entered the home and searched for evidence, and later interrogated Harris at the station house. Similarly, if the police had made a warrantless entry into Harris's home, not found him there, but arrested him on the street when he returned, a later statement made by him after proper warnings would no doubt be admissible. This case is therefore different from Brown v. Illinois, Dunway v. New York, and Taylor v. Alabama. In each of those cases, evidence obtained from a criminal defendant following an arrest was suppressed because the police lacked probable cause. The three cases stand for a familiar proposition that the indirect fruits of an illegal search or arrest should be suppressed when they bear a sufficiently close relationship to the underlying illegality. We have emphasized, however, that attenuation analysis is only appropriate where, as a threshold matter, courts determine that the challenged evidence is in some sense the product of illegal governmental activity. Attenuated analysis is only appropriate where, as a threshold matter, courts determine that the challenged evidence is in some sense the product of illegal government activity. United States v. Cruz. Harris's statement taken at the police station was not the product of being in unlawful custody. Neither was it the fruit of having been arrested in a home rather than someplace else. The case is analogous to United States v. Cruz, Supra. In that case, we refuse to suppress the victim's in-court identification despite the defendant's illegal arrest. The court found the evidence was not come at by exploitation of the defendant's Fourth Amendment rights. And that it was not necessary to inquire further or whether the taint of the Fourth Amendment violation was sufficiently attenuated to permit the introduction of the evidence. Here, likewise, the police had a justification to question Harris prior to his arrest. Therefore, his subsequent statement was not exploitation of the illegal entry into Harris's home. The warrant requirement for an arrest in the home is imposed to protect the home and anything incriminating the police gathered from arresting Harris in his home. Rather than elsewhere has been excluded as it should have been. The purpose of the rule has thereby been vindicated. Even though we decline to suppress statements made outside the home following a patent violation, the principal incentive to obey patents still obtains. The police know that a warrantless entry will lead to the suppression of any evidence found or statements taken inside the home. If we did suppress statements like Harris's, moreover, the incremental deterrent value would be minimal. Given that police have probable cause to arrest a suspect in Harris's position, they need not violate patent in order to interrogate the suspect. It is doubtful, therefore, that the desire to secure a statement from a criminal suspect would motivate the police to violate patent. As a result, suppressing a station house statement obtained after patent's violation will have little effect on officers' actions one way or another. We hold that where the police have probable cause to arrest the suspect, the exclusionary rule does not bar the state's use of a statement made by the defendant outside of his home, even though the statement is taken after the arrest made in the home in violation of patent. Justice Marshall, with whom Justice Brennan, Justice Blackmun, and Justice Stevens joined dissenting. We have identified several factors as relevant to the issue of attenuation: the length of time between the arrest and the statement and presence of intervening circumstances, and the purpose and flagrancy of the violation. See Brown, ... An application of the Brown factors to this case compels the conclusion that Harris's statement at the station house must be suppressed. About an hour elapsed between the illegal arrest and Harris's confession without any intervening factor other than the Miranda warnings required by Miranda. This court has held, however, that Miranda warnings alone and per se cannot assure in every case that the Fourth Amendment violation has not been unduly exploited. Brown. Indeed, in Brown, we held that a statement made almost 2 hours after an illegal arrest and after Miranda warnings had been given was not sufficiently removed from the violation so as to dissipate the taint. Okay, so as to the flagrancy of the violation, petitioner does not dispute that the officers were aware that the Fourth Amendment prohibited them from arresting Harris in his home without a warrant. Notwithstanding the officers' knowledge that a warrant is required for a routine arrest in the home, the police went to defendant's apartment to arrest him, and as the police conceded, if defendant refused to talk to them, they were to take him into custody for questioning. Nevertheless, they made no attempt to obtain a warrant through 5 days, although 5 days had elapsed between the killing and the arrest, and they had developed evidence of probable cause early in their investigation. Indeed, one of the officers testified that it was departmental policy not to get warrants before making arrests in the home. From this statement, a reasonable inference can be drawn that the department's policy was to suspects that strengthen their case with a confession. Thus, the police illegality was knowing and intentional. In the language of Brown, it had a quality of purposefulness. In short, the officers decided, apparently consistent with a departmental policy, to violate Harris's Fourth Amendment rights so that they could get evidence that they could not otherwise obtain. As the trial court held, no more clear violation of patent, in my view, could be established, whereas here there is a particularly flagrant constitutional violation and little in the way of elapsed time or intervening circumstances. The statement in the police station must be suppressed. But the majority does not apply the Brown factors in this case. In the majority's view, when police officers make a warrantless home arrest in violation of patent, their physical exit from the suspect's home necessarily breaks the causal chain between the illegality and the statement by the suspect, such that the statement is admissible regardless of the Brown factors. The majority's per se rule in this case fails to... So this is a per se rule, even though they didn't want to give a per se rule. In this case, fails to take account of our repeated holdings that violations of privacy in the home are especially evasive. Rather, its rule is necessarily premised on the proposition that the effect of a patent violation magically vanishes once the suspect is dragged from his home. But the concerns that make a warrantless home arrest a violation of the Fourth Amendment are nothing so evanescent. A person who is forcibly separated from his family and home in the dark of night after uniformed officers have broken down his door, handcuffed him, and forced him at gunpoint to accompany them to the police station does not suddenly breathe a sigh of relief at the moment he is dragged across the doorstep. Rather, the suspect is likely to be so frightened and rattled that he will say something incriminating. These effects, of course, extend far beyond the moment the physical occupation in the home ends. The entire focus of Brown factors is to fix the point at which those effects are sufficiently dissipated that the deterrence is not meaningfully advanced by suppression. The majority's assertion, as though the proposition were axiomatic, that the effects of such an intrusion must end when the violation ends, is both undefended and indefensible. Perhaps the most alarming aspect of the court's ruling is that practical consequences for the deterrence of patent violation, period. Imagine a police officer who has probable cause to arrest a suspect but lacks a warrant. the officer knows if he were to break into the home and make arrests without first securing a warrant, he would violate the Fourth Amendment and any evidence he finds in the house, to use any evidence inside the house either for the simple reason that he will never see it. The officer also knows, though, that waiting for the suspect to leave his house before arresting him could entail a lot of waiting, and the time he would spend getting a warrant would be better spent arresting criminals. The officer could leave the scene to obtain a warrant, thus avoiding some of the delay, but that would entail giving the suspect an opportunity to flee. More importantly, the officer knows that if he breaks into the house without a warrant and drags the suspect outside, the suspect, shaken by the enormous invasion of privacy he has just undergone, may say something incriminating. Before today's decision, the government would only be able to use that evidence if the court found that the taint of the arrest had been attenuated. After the decision, the evidence will be admissible, regardless of whether it was the product of unconstitutional arrest. Thus, the officer envisions the following best-case scenario if he chooses to violate the Constitution. He avoids a major expenditure of time and effort, ensures that the suspect will not escape, and procures the most damaging evidence of all, a confession. His worst-case scenario is that he will avoid a major expenditure of effort, ensure that the suspect will not escape, and will see evidence in the house which could have remained unknown absent the constitutional violation that cannot be used in the prosecution's case in chief. The court thus creates powerful incentives for police officers to violate the Fourth Amendment. In the context of our constitutional rights and the sanctity of our homes, we cannot afford to presume that officers will be entirely impervious to those incentives.